Hey, what is up? Good afternoon, everyone. Welcome to Internet Law Review. We are going to be discussing the lawsuit involving Vic. I want to make sure I get his last name pronounced correctly. Is it Mignogna? But we're going to cover the lawsuit. But before we get to that, because it is September the 11th, I wanted to start with a brief mention of that. So the image on screen, I thought this was a nice image given all things considered. This is a memorial to September the 11th that is located in New Jersey. And what is particularly nice about this memorial is that it was donated to New Jersey by Russia. And so, given all the sort of problems our two countries have had, I thought it might be nice just to take one moment to remember a time when Russia gave the United States something to remember a true tragedy in the United States. So, this is just a reminder that, this is something that impacts us all, and a reminder that even our adversaries can be someone who, is helpful to us. So, um, yeah, that's really all. I just wanted to give a moment to remember that 3,000 Americans died, and there's a conflict that's still ongoing, and I think it's worthy of mention. So that's all about that. I'm having some bandwidth issues. I'm going to change one thing. Hold on one second. I might drop for just a second. Okay, hopefully that fixed that problem. Sorry, I wanted to make sure to get the bandwidth up. Anyways, so let's cover the main reason why we're here. His name is Mignogna. Thank you for this one to say. Help me with his name, Nick Mignogna, Vic Mignogna. So we're going to cover this, and we'll just start with a article that sort of covers the highlights, and then we'll actually get into the legal filings. So this is from Variety. It says Vic Mignogna, known for voicing Broly in Dragon Ball games, films, and TV shows, filed a lawsuit claiming defamation and other charges against Funimation and other voice actors, according to public documents. Fellow Funimation voice actors Monica Rial and Jamie Marici, along with Rial's fiance Ronald Taw, are also named in the suit. Mignogna's suit stated that he's suing for interference in other work contracts, and the charges made against him, accusing him of sexual harassment, are false and affected his career. And he's suing for more than $1 million in relief. All right. So that just gives enough predicate. So we're going to cover 4 documents today. We're going to cover the amended petition, the amended complaint. We're going to cover the defendant's original answer. We're going to cover the defendant's motion to dismiss. And we're going to cover Vic Mignogna's response to the motion to dismiss. Now, my understanding is that there was a hearing on this issue this week, and that a judge has dismissed some of the claims. I believe, according to reporting, he's dismissed all the claims dealing with interference of contract. But I don't know anything about this case other than the pleadings we're going to read together. So I'm going to read them and try to give you my best impression of what I think of the case based on what I'm reading. Of course, there are a lot more filings than this. There have been depositions, paperwork, exhibits, all kinds of things. But, we're talking hundreds and thousands of pages in court filings. So we're just going to read sort of the major documents, and we'll have a follow-up video to discuss anything that we need to follow up on if there's more things to provide us additional context. But this should be enough to give us a rough idea of what's going on and the rough strength of the relative issues. So let's starting with the original complaint. So this is Victor Mignogna versus Funimation, Jay Marici, Monica Rial, and Ronald Toy. And of course, standard caveats apply. These are the parties' filings, not a judge's decision. So we should interpret everything with the appropriate amounts of grains and salt. Everyone is going to put their best case forward. So we should assume they're going to heighten the facts that are favorable and try to diminish facts that are disfavorable. So we should interpret everything with the appropriate amount of skepticism because we're reading people who are not disinterested. They are interested in the outcome. I am disinterested. I'm not getting paid by anyone. It doesn't affect me personally, so they are biased, and hopefully I will be able to provide a somewhat more neutral opinion. But let's read what they say the facts are. Vic is a voice actor who has performed the voices of anime characters for over 22 years, namely in anime productions. Vic does not physically appear in these productions. Only his voice is used for the English dubbing or revoicing of the Japanese voice actors. Monica and Jamie are also voice actors. Both have worked for Funimation. Ronald is Monica's fiancé. Funimation primarily dubs Japanese anime properties into English for distribution within the United States and provides streaming access subscription services to these properties via their websites. In June 2017, Funimation contracted with Vic to provide the voice for dubbed anime properties it was distributing within the United States. For example, he was cast as the voice of Broly. In addition to his voice work, he attends fan conventions, 30 to 45 a year. On January the 16th, Monica liked and retweeted the tweet of someone with the Twitter handle Helenia that accused Vic of being a homophobic, rude asshole who has been creepy to underage female fans over the years. The next day, Monica liked and retweeted 2 tweets by Karen Saucedo, who posts under the name Marzi Girl, that accused Vic of great volumes of sexual misconduct, urged Funimation to reconsider hiring Vic Mignogna as a voice actor in the future, and initiated the hashtag #KickVic. The repeated attention that Monica, Jamie, and other Funimation agents, employees, or business partners gave Helenia and Marzi Girl's accusations caused their tweets to go viral. About the same time, one or more defendants began actively defaming Vic directly to anime conventions, speaking of investigations and of Vic getting fired. Okay, so we're accusing the defendants of engaging in active attempts to defame. I'm not sure that merely liking or even retweeting a tweet would qualify as defamation. I don't know that's enough action, but I don't know what the courts would say on that issue, but it doesn't seem sufficient to qualify as a republication to me. But if they're doing more in terms of actually acting in their own voice, that could be a lot more. Also, so far, the tweets we saw seemed more based of opinion rather than based on fact. The repeated attention that Monica, Jamie, and other Funimation agents, employees, or business partners gave these accusations, we read that. Barely a week later, a Sony executive informed Vic that she was investigating the allegations of sexual harassment against him. One, Monica alleged to have occurred 6 years prior at a convention where, after she wrote her name on a jelly bean and gave it to him, Vic ate the jelly bean and joked that he ate Monica. Just on a purely personal level, that seems a little bit thin to qualify as sexual harassment, but that's just me. Vic denied any sexual suggestion. He was joking in response to a fan asking if he can be poisoned by the ink. Monica also alleged inappropriate conduct between Vic and 2 fans at a convention 3 years prior. Vic emphatically denied any appropriate conduct. So far, let me get this straight. We're alleging that Vic, 6 years before, had ate a jelly bean, and 3 years before that, he had engaged in some sort of conduct, which might seem some thin. And then a third single kiss. I mean, it seems pretty thin for any kind of accusation to me. Denbo's telling Vic that her investigation was a confidential matter did not stop Jamie, Monica, or Ronald, or other Funimation employees or business partners from urging anime conventions and other studios to terminate their contacts with Vic. Well, that's perfectly valid. Denbo's role here is as an HR representative within the company, doing an investigation as to determine whether an employee should be disciplined. So her investigation is confidential while she's undergoing that. But of course, just like pretty much any investigation, whether it's police or otherwise, witnesses and victims and anyone else can tell their story. So if this were a criminal matter and the police were investigating, the police would tell you that their investigations are confidential. That wouldn't preclude a person from saying what they saw or heard to someone else. What the police hold in confidence doesn't bind people who aren't the police. Likewise, this internal HR person's confidential investigation doesn't bind anyone else, so you wouldn't expect it to. Um, let's see. They were telling Funimation was involved in an investigation into allegations that Vic was a sexual predator, or charges were being filed against Vic and he would soon be arrested, or tweeting details about the investigation. For example, Ronald would tweet that Vic is a predator based on insider knowledge. Well, that is a bit of a problem. When you're saying something like that is a predator and talking about insider knowledge, that's a mixed opinion fact. When you give an opinion based on hidden knowledge or secret knowledge, that's usually enough to constitute defamation. So if what you're saying is, well, this is my opinion is informed by facts known only to me, that's usually defamation because the opinion implies the facts. And so that's sort of the rationale from the courts there. So when you're talking about insider knowledge, that would seem to be a potential trigger for defamation. The fallouts from defendants' actions was swift. The Phoenix Fan Convention canceled the appearance. A few days later, Ronald tweeted that Vic was a predator, a charge that Ronald would repeat at least 15 more tweets. Predator is unclear. Is that a statement of opinion or a statement of fact? What does it mean for someone to be a predator? It's not saying that he did X on Y date or that he was seen to be doing this or implying any particular action. Whether someone's a predator or not seems more opinion on its surface to me. On January 2019, Den Bone, another Sony executive, informed Vic his employment was terminated following the investigation. Okay, as a private company, presumably they can fire him as they like. Although because he's a voice actor, I would presume he's employed under some sort of contract, and so we'd have to go in terms of the contract, in terms of the rights there. But every contract I've ever read almost always has a carve out for sort of issues of character like this. So it probably was sufficient as a basis of contract. And they'd have to, if he had an issue with that, he'd have to raise it as a contract issue. January 30th, the Anime New York City Convention and Milwaukee Conventions canceled the appearances. In a January 31st tweet, Ronald claimed to know of at least 4 assaults by Vic and crowned, "I'm glad to see the conventions canceled." And they canceled the Vic's appearance. He's saying, "I know of 4 assaults." That's more of a statement of fact. An assault is a crime. And you say, "I know of something," that seems like a statement of fact. That's not opinion. Ronald tweeted he personally knew Vic was guilty of 4 counts. That sounds like a fact. That day, the Dallas convention canceled the appearance. However, he's reinvited to that appearance later. Ronald tweeted Vic needed to prove himself to be not a predator. How do you prove a negative is always a good question. Prove you're not a predator, right? It's basically impossible. Someone said Funimation hires its voice actors as independent contractors, not employees. Fair enough. But as independent contractors, the name, as it suggests, the name contractor means there's a contract, right? And so again, you'd be looking to the terms of the contract. So you'd still have the same underlying question as to like whether firing him would be a breach of contract or not. So you want to look to the provisions of the contract. But again, most contracts for employment or for as a contractor have sort of a morals clause of some kind. So it wouldn't be surprising if this one did as well. In February 2019, Ronald tweeted multiple times Vic was a predator, called him a perp, and asserted there's over 100 counts and still more to come. That seems like a statement of fact. Denver Comic Con canceled the appearance. And we have the tweet here. He's down because he took advantage of girls' bodies. How about get a grip on reality and stop harassing people? For 100 accounts, there's still more to come. And you defect this second shift, get a life. Well, 100 accounts is a statement of fact, so I hope someone's actually documented that, right? On February the 5th, Funimation informed Anime News Network that Vic's employment had been terminated, and Ronald again tweeted his accusation Vic is a predator. Funimation informing Anime News Network that his employment had terminated. I don't know if that would be routine or not in this industry. Would that be a typical thing that would normally happen if they normally don't employ someone or terminate someone? Is that like the kind of thing you'd normally report? Because this is like an industry trade, so who's being hired and who's being fired and stuff like that is the kind of thing you see all the time. So maybe this is just routine. I don't know. On the next 24 hours, Florida, Raleigh, Camicon, and Hudson Valley canceled Vic's appearances. Ronald tweeted over 100 women have made accusations of assault. The allegations were corroborated. Well, that's an additional statement of fact. Now you're saying by corroborated, in case they are confused, corroborated means that there's some sort of additional evidence other than just testimony, some sort of physical evidence, or or a second party, or something other than just one person. Corroboration requires some additional validation. There were mountains of testimony. Well, are there or aren't there? That's a statement of fact. And Funimation have proof. That's why they fired him. Well, I hope you know that, because you're making statements of fact now. That's not opinion. Calling someone a predator is probably opinion. Saying there's mountains of testimony, saying that they have this evidence, saying that there's 100 with corroboration, those are statements of fact, man. That's not so great. Monica, Ronald's fiance, also tweeted that it happened to me. I'm only one in a sea of voice of many. He's heard enough people. He's a sick man, needs help. Well, Monica presumably would or would not know what actually happened to her, so but then again, she could be just making it up. But so that's again a statement of fact, and so we could go to the truth of that. It happened to me as a statement of fact. Jamie attempted to rebuff these questionings and the veracity of the point. Says, yes, I want his head, I want his balls, I want him to feel an ounce of pain he caused others, and then fucking choke on it. I want you to take his dick out of your ear so you can actually hear reality. But that's just me. And what about innocent until proven guilty? Works in a court of law. Sometimes name and shame is the fastest way to the courtroom. It's an extremely fast way to the courtroom in a defamation suit if you're making stuff up. False statements of fact are a problem. 2 days later, Jamie tweeted that Vic had assaulted her several years prior by grabbing her hair and whispering in her ear. What she whispered, she couldn't remember. Then in the last week or so, I've heard of accounts of him doing the exact same thing to half a dozen other women I know, and he's a predator. Okay, well, if it actually happened to her, she can testify to it. And if other people are saying very, very similar accounts, that would be like an MO, right? A modus operandi. If you see the same thing in multiple cases, then that sort of gives some additional validation. And there's some case law on that in the criminal context for that, where you can say because this applies, therefore we can make some reasonable deductions. So it gives some validation as to why that would be true, or why she would believe it, and why it wouldn't necessarily be malicious if it were based on her own experience of a very similar incident. In 2019, Funimation made its investigation public via Twitter. Questionable as just a sort of a policy position, but okay. Determining Vic had engaged in harassment or threatening behavior. Monica responded, there were multiple investigations with testimony, proof, and evidence. Those are statements of fact. Funimation says, everyone, we want to give you an update on the Vic Mignogna situation. Following investigation, Funimation recast Vic Mignogna in Morose Monokian Season 2. Funimation will not be engaging Mignogna in further productions. Part of our core mission is to celebrate the diversity of the anime community and to share our love for this genre and its positive impact on us all. We do not any kind of harassment. That's what it says. We do not any kind of harassment or threatening behavior being directed to anyone. Missed a word there. We do not condone any kind of harassment or threatening behavior being directed to anyone. You corrected yourself. If Vic was fired, then Monica should be as well, since they both caused the problems, harassing fans. Both sides should be recast. That way it's fair, until investigation is done. Seriously. There are multiple investigations with testimony, proof, and evidence. Companies don't cut ties without those things. Well, I mean, that's not strictly speaking true. Companies cut ties for PR reasons all the time. If there's enough blowback, they'll cut your losses because they're a business. So, just saying. However, that information is classified. Well, if it's classified, Monica, how do you know about it? You're making statements of fact that they do in fact have these things, and now you're saying they're classified. So that's a bit of a problem now, isn't it? I am one of dozens of men and women who participate. Stop harassing me. Okay. Later that day, Monica declared Vic is the legal definition of harassment. And just so we're clear, he's the legal definition of harassment. Harassment is governed by state laws, but it's generally defined as a course of conduct which annoys, threatens, imitates, alarms, or puts a person in fear of their safety. That's a reasonably rough definition of harassment, yes. Especially if, like, they've told you it's unwanted conduct. You know, if they've put you on notice, that's particularly helpful. Over the next week or so, Ronald tweeted, evidence. He's been fired. There was an investigation. These actions have corroborated testimony. Okay, none of those things are evidence. He's been fired isn't evidence. There was an investigation isn't evidence. These actions have corroborated testimony. Well, that would be evidence if you would tell us what it is. Their decision was based on things that happened to Funimation employees. And let's see who walks away as a registered sex offender. Okay. In 2019, Monica tweeted a lengthy post in which she accused Vic of sexual harassment, kissing her without consent, and treating others similarly at conventions. Well, I don't know necessarily how you would know whether or not he had consent from those other people or not. I mean, unless they told you, or it was like readily apparent, but okay. She claimed to have spoken with investigators to corroborate the testimony of others, telling similar stories to her, and spoke to Funimation's investigations. She closed by referring to Vic as a predator. The investigations were incredibly thorough. Each person was interviewed, the evidence weighed, and a decision made. Okay. Each company has to look out for the safety of employees, and incidentally, their own reputation and PR and, all that rest. In this instance, these companies felt they had made the best decision to protect their employees and or bottom line, and contract workers. Also, these companies aren't obligated to share information with you. That's fairly true, and they probably shouldn't, as a matter of course. It's not a good idea to drag people through the mud. It's a private deal. Many of the women who come forward have chosen to remain anonymous, especially after seeing the way I was attacked. Please respect their privacy. Okay. Ron continued carpet bombing Vic with Twitter, accusing him of assaulting Monica, of cheating on his fiancée, assaulting ladies, and robbing fans. Robbing? Like stealing physical stuff? That'd be a problem. And assaulting way more people than Monica, forcing himself on people in a sexual manner without consent, and that resulted in assault. Okay. Ron has tweeted more than 80 times that Vic sexually assaulted or assaulted Monica. More than 10 times Vic sexually assaulted 3 of his very close friends. More than 10 times he's accused hundreds and possibly thousands of assaults, and 17 times he's a predator. Predator is probably a statement of opinion. The rest of it sounds more like statements of fact. To say you sexually assaulted someone is a fact. To say you assaulted someone is a fact. To say you sexually assaulted 3 friends is a fact. That there's hundreds of assaults or thousands of assaults is fact. Predator is probably opinion. Vic sent written requests for correction, clarification, or retraction in compliance with the Civil Rights Code to various people. Okay. Defendants, so our first cause of action is defamation. Defendants have tweeted false, defamatory statements about Vic that are published and read by third parties. Indeed, many of defendants' tweets are defamatory per se. So, in your standard defamation case, you need to show 3 things. You need to show that you make statements of fact that are false, and you need to show damages. So they need to be statements, false, and damages. Or facts, false, and damages are your 3 major things. In a per se case, you don't need to show damages. Damages are presumed. Standard defamation per se at law is allegations relating to sexual misconduct or sexual conduct, and allegations relating to job, professional performance. So these would seem to fall within the broad scheme of defamation per se. Defendants knew the statements were false or made them with negligent disregard. If you actually know they're false, you're totally hosed. Negligent disregard for truthfulness would only typically apply if it's a public person. Due to defendant defamation, Vic has suffered actual and consequential damages in excess of the jurisdiction, and it was willful, fraudulent, malicious, and in wanton disregard for Vic. So, giving punitive damages. Okay. Now we get some tortious interference claims, as I understand, have been dismissed, but we're going to read them anyway so that I can give some independent thoughts on them. Vic enjoyed contracts with multiple conventions prior to the defendant's tortious conduct. So here, tortious just means improper conduct, if you like. Defendants knew of the contracts. However, defendant willfully and intentionally interfered with those contracts, approximately causing the cancellation, termination, and even breach of the contracts by convention producers, causing Vic actual and consequential damages. On its surface, I like this cause of action. I don't, by that statement, mean that I think the judge is wrong. It's a very superficial claim, but on the surface, sounds initially plausible at least. I'm pretty sure this is the Second Amendment complaint. Second amended complaint. Yeah, it's the amended petition. See at the bottom of the page where it says plaintiff's amended petition. So this is the amended version. There was reasonably possibility that Vic would have entered into agreements with other production companies and conventions, as he had in prior years. The defendants knew of these relationships, however. Defendant unlawfully and independently tortious actions prevented these agreements from occurring. Defendant's actions were not merely an incidental result, but were unlawful and taken without justified cause. Indeed, the defendant's motivations motivated by malice. I don't know if that's like a misspeaking or if he actually means that, because I know we're not talking about defamation, but malice in defamation law and malice here are like two completely different meanings of malice. So when he writes malice, does he actually mean hatred? Okay, I don't know. Defendant's tortious interference approximately caused damages. Again, it's my understanding that this cause of action has been dismissed. On initial read, it sounds pretty plausible to me, but again, this is a very thin thing, and the judge has seen a lot more material than this. So I'm not saying the judge made the wrong decision, nor am I saying he made the right decision. I'm just simply saying that on initial read, it sounds like a plausible cause of action to me. And if I were the attorney, these are the kinds of causes of action I would be making. Defamation, tortious interference, these are the things that pop into my mind. So it's not in any way an unreasonable cause of action. These are like what I would naturally be going to. So it all seems very reasonable. Civil conspiracy. Defendants conspired and acted in concert to defame Vic unlawfully, or alternatively, lawfully by unlawful means, interfere with existing contracts, and unlawfully interfere with prospective business relationships. Okay, so if your standard conspiracy, you need to have two people that have an agreement, and one of them has to take some affirmative step to execute the agreement. So as long as two or more people had an agreement to do something, and one of them took a step to execute that thing, that's conspiracy. So initially, again, seems plausible. Robert says he means that. Fair enough. It's just, because it means two different things in two different contexts, I just wasn't sure if it was sloppy or if he meant it like literally. Vicarious liability. At all relevant times, Jonica and Monica were Fundimation's employee and acting in the scope of employment. Okay, well that's actually really important because of a concept called respondeat superior. So if an employee of a business injures you, the business is responsible for that, because as long as they're acting within the scope of their employment. So if you employ a person and that person in the scope of their employment causes harm, the business is responsible. So it's a very fancy term called respondeat superior, but basically means that the principal, the person who is hiring, is responsible for the acts of the agent when the agent is performing in the furtherance of their charge, what they were asked to do. So Jamie and Monica being Fundimation's employee means that Fundimation is not only responsible for whatever they do directly, they're also responsible for what Jamie and Monica do because they're employees, as long as they were acting within the scope of their employment. So that's why that's really important, because of that liability, and that's what they're talking about. Vicarious liability is, A therefore B, B therefore C, A to C. That's vicarious, right? So that's exactly what we're talking about. Respondeat superior, agent, principal, liability. Jamie, Monica, and Ronald were the agent with actual or apparent authority to act on behalf of Fundimation. Accordingly, they were liable. Again, seems perfectly correct on its face. No major problem. Here's a whole bunch of false statements. Here's a whole bunch of specific things they did. A lot of these things seem very statement oriented. They're making representations about facts. Are these statements false? If so, it seems like damages per se. And so then the only remaining question would be if he's a public figure or not. And I'm sure we're going to get to that in some of the responses. So we'll wait till we get that far. All right, let's see what the answer was. As I stated at the top of the plaintiff's complaint, I will state again in the response to the answer. Again, this was written by the party, so we should assume that it's written in the most favorable light possible, and so we should interject skepticism. That's why I was trying to be skeptical with respect to what the Victor was saying, because he's obviously going to put forward the best possible light, so we need to put in some doubt, because it's probably not 100% correct. It would be hard for it to be. And same thing here. We're going to assume that it's written in the best possible light. So let's see what we said. For years, women nationwide have complained publicly that plaintiff Vic Mignogna sexually harassed, intimidated, or groped them. And they point to some sort of post, which I don't have and maybe is attached, but if they're relying on the statement of others, that could be some basis for them to make the statement. These complaints come from underage fans. How do you know they're underage? Attending conventions and respective voice actors who have experienced his degrading behavior. It's no surprise that Mignogna now intends to blame everyone but himself for his misconduct. This lawsuit is nothing more than a desperate ploy by a disgraced actor to drag down others with him and a continuation of harassment that has ruined his once noteworthy career. Mignogna is a public figure, so see they're going right to public figure analysis, because if you're a public figure, you have to show malice in addition to the additional factors, and malice here means reckless disregard of the truth. So we're going to see what their analysis looks like in terms of public figure, and we'll see what we think about it. Mignogna is a public figure known in his voiceover work for characters in English dubs of Japanese anime shows and his role as Captain Kirk in a fan fiction show called Star Trek Continues. Anime is a genre of stuff. I don't care. Following the premiere of Dragon Ball Broly, which features Mignogna's vocal work, accusations of sexual harassment, some which included minors, began surfacing. Soon, victims of Mignogna's sexual harassment and inappropriate conduct started coming forward and began posting their experiences online, with some going back as far as 1989. Mignogna's predatory tendencies are well documented. In fact, there's a number of sites dedicated to sharing stories of inappropriate behavior with women, including the Tumblr blog Dear Vic Mignogna. Okay, that's something. Many victim stories continue to pour through all forms of social media, detailing times when Mignogna acted inappropriately towards them, fondling, kissing, groping, etc., without their consent, most while they were still underage, and include allegations of sexual harassment and sexual assault and harassment. In addition, there are collections of articles, posts, tweets, all detailing allegations of the Vic Mignogna and the sources. Okay. So, are we basing our statements? Are the defendants basing their statements off of these various reports, or do they have statements of their own? Do they have personal knowledge? Let's read on. In 2019, Beth Elderkin of IO9 published an article entitled "One of AMA's biggest voices accused of sexual harassment," which details the sexual harassment allegations against Mignogna and how they've led production companies to terminate ties with him. Elderkin spoke with 25 voice actors, cosplayers, industrial professionals, convention employees, and former fans. That article describes Mignogna as a 56-year-old man who aggressively hugs, grabs, touches, kisses, and propositions women, often without asking for their consent. Well, as to that last part, I'm not sure how you would proposition someone with their consent. How would that even work? You know, a proposition is by its nature a question. How do you ask a question with consent? I don't know. Now, the rest of it, I can definitely see how that would be a problem. If you're hugging, grabbing, touching, kissing, that could potentially be battery, depending on the nature of it, and it could certainly be aggressive. But I'm not sure how you ask a proposition with consent. That seems odd. It happens at panels and autograph lines at private events and behind closed doors. His behavior has been known in the anime and conventions for some time and is more than an open secret. Can you ask me a question? Sure, you can ask me a question. I'm reading along, and if I'm missing questions along the way, but sure, of course you can ask me a question. Yes, now that I have your consent. Well, you didn't have my consent to ask. Can I ask you a question? Now, did you? You asked, Can I ask you a question? You didn't have my consent to ask that question. See what I mean? Yeah. Welcome to reality. You can't. The first underlying question has to be without consent. Yeah. Thanks for trying to trip me up, but it doesn't work. The very nature of a proposition means you don't have consent. So you had my permission for the second question, not the first. Shame on you. Anyways, carrying on. A proposition is asking for consent. Well, presumably, a proposition is it's a asking for something. It's a request or an invitation of some kind. It's a proposal. It's an invitation. It's a would you like to? So yeah. When the sexual harassment allegations became known, the production companies who Mignogna worked for conducted their own investigations. When their investigations were concluded, they terminated and publicly announced they'd no longer work with him. For instance, Rooster Teeth Production is an American media entertainment company headquartered in Austin, Texas, and known for an animated series. Mignogna had a role as a voice actor. On February 2019, Rooster Teeth severed their business relationship with Mignogna. A post on Rooster Teeth's website said, effective today, Vic Mignogna is no longer part of the cast, and they're ending all associations with Mignogna. Rooster Teeth's decision followed in the wake of allegations levied against him regarding kissing and embracing female convention attendees without their consent. Well, that kind of, in some ways, defeats... I don't know that I necessarily would make this argument, because it goes directly to what Vic is allegation. This is basically Vic's argument. He's like, yeah, of course they did all those things. That's my point. My point is that they terminated my relationship following all these allegations which are false. So, I'm not sure that as defense counsel I'd make this argument here. Anyways, carrying on. Co-defendant Funimation also investigated allegations of ongoing inappropriate conduct and accordingly terminated its relationship with Mignogna on or about 2019. Funimation confirmed on Twitter that they had ended professional ties following the investigation. In addition to Rooster Teeth and Funimation, multiple anime conventions withdrew Mignogna from their guest list. Despite numerous voice actors and individual victims that have come forward and publicly described their own sexual assault, Mignogna brings suit against defendants Monica Real and Jamie Marachi. For some reason, they have drawn the ire of Mignogna. Well, what do you mean for some reason? They have, basically, according to Vic, been saying all kinds of nasty things about him. But, that kind of draw my ire too, right? Yeah. Mignogna is well aware that women have spoken truthfully about their misconduct for decades. Someone said the point of bringing Rooster Teeth is because RT fired him first and they're not being sued. Yeah, I don't know that, again, whether Rooster... They may not have a argument against Rooster Teeth because it would go to the same underlying questions. His cause of action against Rooster Teeth, if at all, would be for breach of contract. He was improved by employed by them as an independent contractor or employee or otherwise. And so they fired him. So his cause of action would be contract. If they fired him because of the false statements of other people, it's still just a breach of contract claim. It's not a defamation claim. They didn't defame him by firing him. They, at best, breached the contract. So it doesn't really suggest anything. You wouldn't expect Mignogna to sue them here because it's not part of this cause of action. His cause of action would be breach of contract. He doesn't have any apparent defamation or even a tortious interference claim against them. So that's why I said. And I would be surprised if the other companies made the statements because, again, usually companies don't make statements publicly about that. That's why some of that was so surprising to me because companies don't make statements for the very reason they don't want to get into a defamation issue. In fact, most employers... When you call an employee, if someone gives you references and you're looking to hire them and they say, can I call your company and ask if you're actually hired? Most companies will only say the dates you were hired. They'll say, did you employ this person? Say, yeah, we employed this person between this date and this date. Why they leave? I won't answer that question. Most prior employers will not answer if they fired or quit or whatever. They will just simply confirm the dates and that's it. Because people are worried about the defamation issue. Someone said RT did make a statement. Maybe they did, but yeah. Anyways, that's why they typically, in the broad scheme, don't. Mignogna's decided to prosecute his grievances in the public forum. However, at the same time, use the courts. I presume they mean use of the courts. Use of the courts to stifle anyone who publicly discusses his long history of sexual abuse and harassment. He has no merit and should be summarily dismissed. Okay, there's special exceptions. Let's see if we care about any of these. They're a little vague. Blah, 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 blah. Don't care. We generally deny it. Defendants specifically deny plaintiff's allegation that all conditions precedent have been performed. Sure. Defendants deny plaintiff complied with requirements of the Defamation Mitigation Act. He mailed a purported request. The request references only examples. Well, if they name specific examples, that might be sufficient. Defendants specifically deny plaintiff requested comply with requirements set forth. It failed to specifically describe all the allegedly false statements. This is an area of Texas-specific law, which I don't know about this Mitigation Act and what you do or do not have to plead. So I'm not going to get into Texas-specific law like that. Defendants are not liable because plaintiffs for defamation are barred by the 1-year statute of limitations. Well, if that's true, that would be an outstanding argument. That would be an outstanding argument. You know, statute of limitations are like, yeah, as the name suggests, a pretty big bar. Statute of limitations usually runs from the date of the incident or the date that you become aware of it or the date you should have become aware of it. So that is a pretty good argument if true. Defendants are not liable because plaintiff's own acts approximately caused the injury. Maybe. They're not liable because they're substantially true. Okay. They're not liable because they consent or because plaintiff consented to and or published these defamatory statements by discussing them in public and social media outlets. No. That's not how this works. That's not how any of this works. If you defame me and then I make a point of republishing it to bring attention to the fact that I've been harmed, that doesn't imply consent. That's no. Come on. No. They're not liable because of plaintiff's previously diminished reputation. No, that's not how that works either. Just because I have a previously diminished reputation does not mean that these statements are not also defamatory. That's not how this works. You're making specific false statements. Those are actionable. My general opinion is not relevant to the issue at hand, except as to damages, maybe. Excuse me 1 second. Defendants are not liable to plaintiff on the grounds that they were induced and provoked to make statements by the wrongful malicious acts. Induced and provoked? I don't know, man. They're not liable to plaintiff pursuant to the failure of the publication doctrine. Find defamatory statements not made published if it's made to a person who knows the statement is untrue. Okay, I guess sure, why not? That makes sense. If I make a statement, but the person I'm communicating with knows it to be false, then there's no defamation because I didn't really make the statement, right? If I say, I don't know, if I say I saw Joe sexually assaulting Jane, but the person they know I'm joking, then I didn't actually say what it said I said, because we both know it's not true. So the context beats the content, basically. So this is the kind of thing that if it's an obvious joke or people know you're joking, then it's not a statement of fact. So that's perfectly fine. Defendants have good reason to believe and did believe that on certain dates and times, various times other than that, they sexually harassed or sexually assaulted women identified in the Fundamation investigation, in addition to third parties who've been victims. Accordingly, the defendants spoke concerning were and are true, and the affirmative are and were substantially true. Well, maybe. I mean, we'll get into the weeds on that, maybe. They're not made with actual malice. Well, they might have a fair point there, because if all these other statements exist in all these other blogs, and then they're making general statements about like things, then it wouldn't be in reckless disregard of the truth, right? Because all these other things seem to be validating. So if there's all this other context and they're making statements in light of that, that would seem to go against the idea of malice. It's not reckless disregard of truth when there is so much external content seeming to validate it. All that other stuff might itself be false, but it's not unreasonable for a person to look at a great accumulation and say there must be some truth, and so I'm going to publish the generalized thing. So that could be true. Defendants are not liable to the extent statements are published by a third party. Maybe, maybe not. You might be responsible for that. As such, the statements were allegations made by a third party in regard to a matter of public concern. They accurately report the allegations made by a third party. Yeah. They're not liable to plaintiff pursuant to the fair comment doctrine. A fair comment doctrine is really about opinion, though. Defendants are not liable pursuant to invited defamation doctrine, and the plaintiff demanded defendants provide proof. Well, if you demand proof, and they provide it, it's not defamation unless the proof itself is false. If you say, I know that you're guilty of assault, and that's false, that's defamation. If I say prove it, and you say, okay, here's how I know, and then you give me a whole bunch of evidence that's false, that's, again, defamation. So, like, inviting proof is not, if the proof itself is false. They're not liable because they're statements of opinion. Some of them are, but a lot of them aren't. Some of them are non-literal hyperbole. Maybe. Some of them might be. They're not liable because they're parody or satire. Well, so far, at least, I have not read any statements that, in my view, seem parodic or satirical. I don't see that so far. They're not liable because the contracts are barred by 2 years statute of limitations. Again, that would be a really good piece of argument if true. Does not identify a valid contract that was subject to alleged interference. That is a very, very fair point. In his initial pleading, he just made a general allegation of there are contracts that you've interfered with. He doesn't say like specifically which contracts. He doesn't really delineate them or itemize them or say, here are all the contracts that were interfered with. That's a very fair point. I mean, he makes some generalized statements about like this convention did this or this convention did that, but he doesn't like say this contract with this person, this contract with this person. He doesn't like list them out in a really like itemized way. He waived or forfeited other contractual rights he might have had. Let's see. The plaintiff's own acts were cause of that. That'll do it. He did not mitigate damages. Possible. Although that would tend to go more to the amount of damages rather than like ultimate liability. And also is true like in torts generally. Like if I harm you, there's a duty to mitigate. And if you don't, I might not be responsible for the difference. But I might still be responsible for the underlying damages. They wouldn't be liable for conspiracy because the underlying claims are without merit. Maybe, maybe not. We learned this recently, sort of, from the whole Trump issue with obstruction of justice. Just because there's no underlying crime doesn't mean that it's not possible to obstruct. So, if the police come and investigate me of something I know I didn't do, I can still engage in obstruction because I can still make efforts to interfere with their investigation. So even though there's no underlying crime, there's still the obstruction. In the exact same way, that we have here, if there is, if I'm engaged in a conspiracy, the conspiracy might be unlawful even if the underlying claims are without merit. So the conspiracy to harm might still be a valid conspiracy, notwithstanding that the other things that spurned from it didn't mature, if you like. Another thing that would be relevant to this in conspiracy or in criminal law, for example, would be like a conspiracy to commit murder is legally different from the murder itself. Because maybe you didn't commit the murder, but you did commit the conspiracy to commit murder. And you see that sometimes in criminal charges where, you'll get charged with murder and they'll find you not guilty, and they'll charge you with conspiracy to commit murder and you are found guilty because it's a legally distinct thing. They're found liable for damages. They seek to reduction under proportional responsibility. Fair enough. So Texas, like most states, says that you get damages for your portion of the responsibility. So if Vic is, say, 20% responsible, his damages would be reduced by 20%. Plaintiff is not entitled to punitive damages for failure to do a correction, maybe. They must be capped under due process, under Texas Damages Act, maybe. Due process, no. And due course provisions law, no. Nice try, but no. Demand a jury trial, sure. At least in federal law, you always demand a jury trial because you can always take it back later. Disclose 30 days service, and they object to an associate judge. Fine. I don't know why it makes a difference, but they seem to think it does, so fine. Okay, so that was the complaint, the amended complaint, and the initial answer. So far, so good. Let's see what we got in terms of the motion to dismiss. So, of course, because this is a motion to dismiss, it's the defendant that acts first. And once again, this is written from the point of view of the person filing it, and therefore should be assumed to be written in a way that is charitable to their position. So let us interpret it with the right amount of skepticism. Plaintiff is a public figure, and his lawsuit is an all-out assault. I hope at one point we're actually going to get to the public figure analysis, because on first blush, my gut impression would be that he's not a public figure. He engaged in some voiceovers for a notable show. He attended some conventions. To my mind, it's not enough to be a public figure. I really hope there's going to be some analysis of this so that we can look at the analysis and critique it. But on gut impression, it doesn't strike me as enough to be a public figure. His name, people who are fans of the show, even people who are fans of the show might not know who he is, but real strong fans would know who he is. But a lot of people might not be able to recognize him at sight because he doesn't, his portrait isn't on the show. It's not like, someone's going to stop him down the street probably most times. People might know his name, but is he a public figure? Would I say Nancy Cartwright is a public figure? She's a lot closer to being a public figure. I mean, she's a lot more notable on a much bigger show. But even then, Nancy Cartwright, is she a public figure? I don't know, man. It's a lot closer, though. Surely is a lot closer. Or Hank Azaria, same kind of analysis. But then again, both those people appear in a lot more public connotations. They appear on major talk shows. They appear on, behind the actors table with that one show, so they appear in a lot more context. So yeah, he's paid to show up and sign autographs, participate in panels, etc. Yeah, does that make him a public figure? I don't know. Hopefully we'll see some analysis and we can see what they say. But my gut impression is it's not enough. Plaintiff's casebook is a standard slap case. He's a famous actor by his own admission, one of the biggest names in the fields. Well, he might be a prolific and voice actor, so he's known in the genre. Okay, maybe. That's a lot closer. His fame has long insulated him from accountability. He had a starring role in what would otherwise be the largest anime movie of all time, but the spotlight unintended consequences of exposing a dark past. Commentators on social media, industry publications, and even other voice actors began discussing long-running rumors of the alleged pedophilia, homophobia, anti-Semitism, and sexual harassment. As public criticism grew, studios began to investigate. The conventions began to disinvite him, and eventually two large production studios publicly ended their relationship. Someone asked, is this a limited purpose public forum, public figure? Might very well be. Limited purpose public figure sounds a lot closer to reality. Someone pointed out he has a fan club and public figure and seen him mobbed. Okay, so he's definitely known within the community. So limited purpose seems closer on point. Um, but let's read on. He saw the writing on the wall and spurs large figures of fans to defend him in order to minimize criticism. His fans have attacked critics. Did he actually engage them and spur them on, or are they just fans and defending them for the hell of it? Allied with internet shock jock who unleashes a nightly torrent of abuse, harassment, and vitriol online. What? Plaintiff's goal was clear. With enough abuse, harassment, and threats, plaintiff's accuser will fall silent. Okay. Plaintiff's lawsuit is the hammer designed to smash Monica Rial and Jamie Mariachi. This is a little bit purple prosy for my taste, but whatever. If plaintiff can silence these two Wyndham, those with less notoriety and power will retreat into the shadows. It's a little bit purple prosy for me. This case is exactly what the statute was designed to stop. Accordingly, the sanction imposed can be commensurate. So basically, he's suing because people are being mean to him rather than making false statements of fact. That's what they're saying. Fine. Plaintiff graduated from Liberty University. I don't care. During the summer of 1989, he invited a teenager to his home, but he really wanted a sexual relationship with a teenager. Well, by teenager, how old is teenager? Anyways. He left Lynchburg. He describes himself as a voice actor, performed the voices of anime characters in 22 years, 350 actor names. He attentions 35 to 40 cons. Sizable income from appearance fees. Appearance fees is more suggestive of a public figure. I mean, people are paying to see him arrive, so yeah, that's definitely more suggestive. Accomplished actor in front of the camera, writing, directing, and starring. 3 film projects, 20 independent albums. Like music albums? Regularly works with all kinds of songs. He produces music? Okay. He has 113,000 followers. I don't know what that's supposed to mean. Power and celebrity is such that few people will go on the record concerning his conduct. Okay. The judge said it was a limited purpose public figure. Yeah, okay, fair enough. That sounds like a lot closer to me. Yeah. Plaintiff has a history of bans or asking not to come back to conventions. Of those in the know and brave enough to speak on the record, it's like, I don't know, it's like a bad Jane Austen novel or something. I just don't like the way this is written. Prior to the disputes, he's banned from these conventions, and more recently in these other conventions. He's been conspicuously actioned from some other convention. This convention is particularly troublesome concerning he was stalking a singer and is caught with 3 underage females in his hotel room. Okay, well, that's a problem. One security professional personally observed Plant for years put it bluntly. Based on personal observations, personal interactions, professional experience, I believe Mignogna is a sexual predator. He does not pay attention to the age of anyone talks to us. He's attracted to you, he'll make it known aggressively. I know a lot more of encroachment into others' personal spaces. I noticed he placed the hands on the wall above the heads, touching females on the shoulders, whispering in their ears. Okay, well, that's a little bit something. A lot of smaller conventions put up with Mignogna because they know his fans will show up and spend a lot of money. That's definitely more suggestive of a public figure. Eyewitness accounts of inappropriate conduct with convention goers are legion. Legion, we say. Yeesh. Resulting in convention attendees lodging complaints. Multiple individuals describe plaintiffs as rude to staff and having a bad reputation. I don't know. That's just like a needless character attack. Why are we bringing this up? Oh my God. Contrary to public persona, Vic's behavior reveals he's not guided by Christian virtue. Why are we bringing this up? I mean, it's just, no. No. Miss Rial is a rape survivor, has worked in voice acting. In 2017, plaintiff invited Rial to his room to watch a video.
grabbed her by the arms and began aggressively kissing her. So he's Netflixing and chilling her, trying to, pushing her onto the bed and climbed on top of her and continued aggressively holding her. Notably, this is the same tactic Plaintiff employed in 1989. Out of fear for herself and career, Rial chose to remain silent. Okay, well, if she has personal experience, this is what happened to me. That's pretty good. Plaintiff's argument of Rial a similar attempt to have sex with voice actor, and then again. Plaintiff harassed and intimidated Edwards, ignoring her resistance and his own pre-existing relationship, in hope of pressuring another woman into compromising himself for his pleasure. I don't like the way that's phrased. I don't like the way that's phrased. It's very sex negative. Miss Edwards felt threatened and her career would suffer by rejecting his advances. Aggressive attempts to bed her the following day exacted his petty revenge by interfering with her pre-scheduled autograph signing. By doing what exactly? But it doesn't say, but whatever. To the outside world, Plaintiff represented he was in a committed relationship. Not only did they live together, they were engaged. During this time, Plaintiff assaulted Miss Rial, tried to have sex with Miss Edwards, solicited sex from a prostitute, tried to have sex with two women related by birth at the same time during convention, so like twins. Okay. Had at least one ongoing sexual relationship while engaged and made mistakes during the engagement, somewhere between 5 and 50 times. Oh, Lord, that's... Yeah. Despite plaintiffs, I won't speak to their relationship with them. Some people have open relationships, so, what that means to them is their business, right? Brandon's reviewing this live. Hi, Brandon. How you doing? How am I doing? Brandon, you can feel free to jump into chat, by the way. Just saying. Despite Plaintiff's prodigious sexual appetite, his bizarre explanation for why people make up stories about him is to get attention. Question. There's something about that you would have done over the past 20 years in the voice acting community that will lend credence to people thinking that maybe you're a sexual assaulter. Answer. No, there are an awful lot of fans out there who are really desperate for attention. They often like to talk about people to get it. Question. And so your theory is that they make up stories about you sexually assaulting them to get attention? Answer. Absolutely. Question. Wouldn't it be better to say, I had sex with Vic to get attention as opposed to saying, Vic sexually assaulted me? Answer. Oh, I'm sure. Give it time. Or if you haven't seen it, I'm sure there's someone out there who would say that. On the one hand, it's possible. On the other hand, there seems to be a lot of people saying it. So, a lot of people it's something, right? It became clear to Miss Beach that Vic lied to her 12-year-old relationship and used fame and attention conventions to pursue sex with many young fans as he could. Vic has no words to express his shame for his conduct. That is just completely unneeded and unnecessary. We do not need that. It is not helpful in any way. All right, let's carry on. One of Vic's most popular characters is Broly from Dragon Ball Z. I'm a bit of a fan of Dragon Ball Z. Not a super fan, but I like it quite a lot. I watched quite a lot of it in the early 2000s when it was on Cartoon Network all the time. I didn't particularly like when Frieza was battling Goku for 18 billion episodes. Never mind, but carrying on. In 2019, a new Dragon Ball movie entitled Dragon Ball Super Broly premiered in the United States. To date, it's grossed $30 million and more than $88 million worldwide. Same day premiere, someone with Twitter handle, someone said he's been a homophobic asshole. Why do you employ a known pedophile linked to alleged sexual misconduct? Okay. Plaintiff weaponizes his fan base and issues several self-serving statements to spin the narrative in his favor. Well, that's kind of what you would expect. And not to put too fine a point on it, but at this moment, you are literally, as you're typing, issuing a self-serving statement to spin the narrative in your favor. That's like how this works. So, yeah, that's what you would think. As allegations of misconduct intensified and perhaps realizing the social climate no longer supported him, Plaintiff arranged an online chat with the Rissenbull Rangers. Who are they? Whatever. This instruction was clear. Do whatever you can to counter all those lies and negativity. Weaponizing his followers is a tried and true practice for plaintiff. They're a fan club? Fine. Do I want to know why that's the name of the fan club? Why they're called Risenbull? What's Risenbull? It's a character from Ed from Full Metal Alchemist. It's from the town Risenbull? Sure. Okay, fine. Weaponizing his followers is a tried and true tactic for plaintiff. For years, plaintiff has hosted what are the anime convention referred to as rumor panels, which he seeks to dispel rumors about himself that are upsettingly similar to communications at issue. Well, I mean, I don't know, like, assuming arguendo that they're false, you would expect him to deny it. Like, denying things is what you would expect. Like, here's a bunch of things that have been said about me. I mean, that seems very sort of like he believes there's nothing wrong. So if by a rumor panel what you mean is you're going to get into a room with people, right, at a convention, and you're going to give like a 30-minute talk, and then you're going to open up the questions. I mean, that's kind of like what you might expect someone who's been falsely accused to do. You know, come hear the truth from me. You know, I'm going to tell you what I have, and then ask me questions, and I'll tell you. So it's like, I don't know why that's bad. Anyways, carrying on. For example, in 2016, plaintiff told the assembled fans at Emanazing in Davenport that women who made allegations against him are merely unimportant people seeking attention to do stupid, mean-spirited, hateful things just to get attention, all because they want someone to notice them. I'd like to also note that those are all statements of opinion. Stupid is opinion, mean-spirited is opinion, hateful things is opinion, just to get attention is opinion, all because they want someone to notice them is opinion. Those are all statements of opinion. If someone was sad and lonely and felt unimportant enough and was desperate to do attention, they thought, I'm going to say something about someone that a lot of people know just to get attention. That's also opinion. He sounded the call for alarms. I mean, this is just a little, it's written a little over the top for my taste. Plaintiff explicitly refers to the hugging and affectionate demeanor, arming his supporters with what continues to be his main defense. His accusers are desperate liars. Yeah, I mean, lying is, yeah. I mean, he seems to think you're all liars. Not only has he been denying it at all these conventions, he's now suing you on the basis that you're all a bunch of liars. So he seems to think that they're all lies. I mean, I don't know what more you want in terms of like he seems to think they're lies. Going to a lot of effort to disprove it. No, that doesn't mean they are lies. They could be true, but you know, he's not acting in a way that's inconsistent with someone who's telling the truth, right? He calls the allegations against him absurd and basically garbage levied by a tiny group of detractors, as if allegations would have more force that there have been more women coming forward. Well, yes, that is definitely a thing. As if the allegations would have more force had there been more women coming forward. Yeah. Yes, that's like a thing. You know, more people saying the same thing makes something like more credible. You know, the more people that come forward and say, this is the true, you know, it reduces the probability that they're all collectively lying, right? Now, they could all be collectively lying, but allegations do have more force when there's more people who say it. That's true of like everything ever. It doesn't mean it's untrue if one person says it. It doesn't mean it's true if 100 people say it. But the amount of people that say it does tend to lend some credibility that, hey, all these people may not be lying, especially if their stories are all really, really similar. Because it like speaks to an MO. So of course you'd expect it to have more force if there's more people. Like, what are you talking about? With his legions ready to pounce and armed with his talking points. Did he actually issue talking points? Plaintiff issued an apology the following day to address years of rumors concerning his homophobia, anti-Semitism, and accusations. And it says, finally, any allegations of sexual harassment, sexual assault, or most disturbingly, pedophilia are completely and utterly false. My heart weeps for anyone who endures a violation of this kind. To be so accused of harming others this way, I have no words. He's indignant. Okay. The attention from the Dragon Ball Super Brawly, along with other ensuring Firestone online, in turn launched a series of online articles recounting excruciating detail the long history of poor reputation. I also I dislike how this is broadening out of the issue at hand. The issue at hand is the statements regarding the sexual harassment and sexual misconduct. I don't particularly like that this motion is bringing in stuff about homophobia and whatever else. That first, it's not the issue, and it's poisoning the well. It's trying to make him seem like just generally a bad person, but it's not the issue. The issue isn't whether he's homophobic. The issue isn't whether he's anti-Semitic. The issue is whether or not he's a sexual assaulter. And so I don't really like this kind of superfluous stuff because it's not relevant to the issue. I didn't. You said I skipped the part where he repeatedly called on his calls for finger fraction. No, I didn't. I mentioned it. I mentioned that they said that they encouraged that. I didn't skip it unless I skipped but I thought I mentioned it. Yeah. Anyways, someone says I like how you're reading this very fair. I'm trying to be fair. I'm trying to be fair to both sides to the issue. I don't have a dog in this fight. I'm just interested in the law. You mentioned talking points, but you didn't think read the quote. Fair enough. I'll go back. Let's see. See, where were we? Mm-hmm. Do you happen to know where that was in the thing? I'll go back to it. Here. He instructs his supporters to do whatever he can to counter all the lies and negativity. Was there a footnote? How demonetized are we already? I don't know. I don't really worry about monetization. Top of 12? He instructs his supporters to do whatever he can to counter all the lies and negativity. With legions ready to pound, says talking points. He issued an apology to their shears of rumors. Yeah, I think I read that part. But, no, okay. So they're saying that he said to instruct them to help recount it. Okay, that's fine. So there's some stuff here. Unbeknownst to the public at large, Funimation conducted an investigation, including interviewing Ms. Rawl and 3 others, and found his explanations unconvincing and quietly terminated. Well, you aren't Funimation. They filed their own. I don't know if they filed their own motion to dismiss. I think they did. But you don't know what they thought. You can't possibly speak to that. You know what they did, but you don't know why. Plaintiff concedes the foregoing articles of defamation damaged his reputation. What? Plaintiff concedes, as he must, the foregoing articles are defamatory and damage his reputation. What are you talking about? It's not that he concedes it. That's what he's alleging. That's like the very foundational basis of his entire argument. It's not that he concedes they're defamatory. That's his entire fundamental complaint, is that they're defamatory. What do you mean concedes? What are you talking about? Anime Rooster Teeth publicly terminated its relationship. He lost 10 convention invites. See, that's at least suggestive, to my mind, of tortious interference. It's suggestive. Terminates relationship with plaintiff. Plaintiff sent an email to Ms. Rawl under the guise of wanting to know what he did wrong. Notably, he did not send an apology email to our 3 women. Well, I'd like to note he didn't send an apology email to Ms. Rawl either. Look at your own phrasing. Plaintiff sent an email to Ms. Rawl under the guise of wanting to know what he did wrong. Well, that's not an apology email. It's a, what did I do wrong? So I don't like the way that's characterized. In 2019, 2 days after Funimation public termination, he issued a Twitter apology. Says not his place to contradict people if they claim they made him feel uncomfortable. Also, uncomfortable is a matter of opinion. You know, so it's not a statement of fact. Nick Ricada, an internet shock jock, is a Minnesota resident who manages a YouTube channel and is allegedly a practicing lawyer and journalist. Ouch. That's mean. Allegedly a practicing lawyer. Oh, that's mean and unnecessary. And you can be a lawyer and a shock jock at the same time. You know, you can have multiple jobs. That's cool. I have no idea if he's a shock jock or not, nor do I at this moment particularly care. Sometime in February 2019, allegedly out of the blue, the shock jock contacted plaintiff directly to express his support for his plight. Sure. In 2019, Ricada set up a GoFundMe campaign for the purpose of funding lawsuits against many possible defendants. Okay, well, people funding lawsuits through GoFundMe is not exactly a new thing. Fine. This fund is set up for Vic's legal defense. There are many possible defendants. I'm not representing him in a legal capacity, but I'm aware of the team who is and coordinate to pay legal fees. The litigation costs are expensive. It's time to fight back. Fine. Great. And only a lawyer would write in all caps, I'm not representing Vic in a legal capacity, because you definitely don't want to confuse that. So, hey. That kind of suggests to me he probably is a lawyer. Let's see, anyways. Plaintiff told 113 Twitter followers that he approved the creation of the war chest. He acknowledged his previous statements had been intended to silence critics, but he failed to do so. Well, yeah. I mean, he's trying to, from his frame, counter these lies. Now, that could be because they're lies, or it could be because it's true, and he's engaging his trolls to, like, you know, be his minions, but, like, that is the point of it, yes. Plaintiff refers to Rikita as a friend and directs his dedicated fans to donate the money to his retaliatory lawsuit. Again, people funding through GoFundMe is not exactly a new idea. The motive for the war chest is explained by a shock jock. I now like how they refer to him as shock jock. They pick that language in a way to smear him, right? So they're picking what's it called? A demontation? I'm not quite sure what the exact word is, but anyways, but they're picking a term to basically like poison the well. It's an ad hom, because they keep describing him as shock jock, where they could say Mr. Rikita, for example, and be neutral about it. They're calling him shock jock to diminish him, which again is not unexpected. You would expect this in this kind of thing. Again, this is written from the point of view of one side. It's designed in its entire intent to make them look as good as possible, the other side make as bad as possible. So assuming, arguendo, that he is in fact a shock jock, describing him repeatedly as shock jock is a tactic designed to lower his esteem before this panel, which is exactly what you'd expect. I'm just noting that it's a thing that's happening because I'm paying attention. There are 100 hours of videos on my motives for contributing to the GoFundMe war chest. The errors of creating it or of not contributing to it. The biggest one is I just don't like any of the defendants. I think they're terrible people. Okay, I want to see them ground in the dust. When you lie to take away a man's livelihood, you deserve to be ground in dust. You're scum and you know it. That's why I created it. Capitalizing on the sensationalism of the dispute, the shock jock has used his YouTube show to generate money for himself and secondarily to threaten the disclosure of personal information. Hey, pretty ugly little liars. I know you're watching even though you never understand me, but just in case you don't realize what it means, is if any of your ideas are discerned by the court, it might not even be me. It might be Casey leaking them to Shane that makes them public. That would be a real shame. That'd be a real shame. It's like your workplace. Let's say there's something who emailed a convention or signing event or something. He's ascertained where they worked. Ooh, that's not so good. That's not something a lawyer would write. That's sounding suspiciously blackmailish. Like, imagine what happens when a person goes out and lies about something to get their job ruined. That person email the workplace gets exposed to the internet. It's just the weirdest thing on earth that would happen for this. That's not great. That's what we would basically suggest could be considered as witness intimidation and or blackmail. You're basically saying if you participate in this process, you're going to be exposed and people might harass you and your employer and you might get fired. That's not really super great. Wouldn't encourage that. True to his word, Rikita and Vic's fans have embarked on a terrifying campaign of harassment and threats of defendants and several witnesses. Don't threaten defendants or the witnesses, particularly because you don't know any of these people. You don't know what's going on. If you want to say these statements aren't true, I know Vic. He's a great guy. He'd never do such a thing. But don't harass people. It's not good. It just makes you look worse. If you harass the other side, it just makes them look better. It's not even smart tactics. And it's not good on a human level. So it's not good legally, it's not good ethically. Don't do it. This, combined with plaintiffs' intent to sue others, has created toxic public debate, instigated by plaintiff as online proxies. In 2019, plaintiff's longtime friend Chuck Huber, who plaintiff claims is a truthful person, floated a proposed statement plaintiff would issue in exchange for Miss Rial and Miss Mariachi effectively recanting their public statements. Okay. This is a proposed statement, apparently. My name is Vic Mignogna, and I'm a sex addict. Addictive behavior is, by its nature, hurtful and mostly unseen to act. I'm working with a therapist to understand my addiction and get healthy. I've never intended to hurt anyone, but so obvious now I did. To the people I hurt, there are no words that'll suffice. All I can say is this experience has permanently moved me towards a better path. I'm doing my best to be a better person. I'm sorry, I'll make amends wherever possible. To the fans who continue to harass and threaten, you're not my fans if you do this. Your behavior needs to change every bit as mine does. Like me, you should be given the opportunity to change. I'm working every day to see the same on the outside as I am on the inside. I only ask for the opportunity to demonstrate that I've changed and continue to work that I dearly love. I'm canceling my appearance at whatever and taking leave from all convention appearances until, in conjunction with my therapist, I am ready to come back. I'll take recovery and return one day at a time. Okay. So, let me see. Plaintiff's longtime friend floated a proposed statement. So his friend wrote this proposed statement, not Vic. So I don't know what a value of anything we just said is, because it's not coming from Vic. So I don't, whatever. Huber even references the legal team as requiring a statement from Mariachi and Miss Rial, and the belief the shock jock would be on board. Again, I note that they refer to him as shock jock. That's being dismissive, and is tainting the well. Mariachi and Rial refused to agree to proposed statements because they were untruthful. What? I'm confused. I don't understand. I thought that was basically your generalized complaint, right? Is that seems in line with what you've been saying. You refuse to agree because they're untruthful. I don't understand. I thought that was exactly what you were saying. I'm confused. Oh, there's two statements, one for them and one for Vic. Oh, we haven't seen the other statement? Well, where's the other statement? We don't get a copy of that? We don't get a copy of the proposed statement that they wrote for them and they're going to tear it apart as being false? We're not going to actually list what that is? That's lame. I mean, I think I would be inclined to include it if I were writing this for them. If I were writing this for them, if they were my clients, I think I'd be inclined to include the statement. I'd be saying, well, here's a statement he was going to write, and here's a statement that he was going to get us to say, and this is completely false because of X, Y, Z, and look what a bastard he is. So I think I would include it. I would include it as basically part of, and then I'd basically color it as saying it's part of his campaign to silence or campaign to silence voices or get away with his things or continue his terror of whatever, blah, blah, So I don't really like it tactically, I don't think. Not including it. I don't quite get that. They refused, even though Huber previewed the vicious online assault that plaintiff would unleash. And please don't mistake this as some weakness on their part. This is my efforts to try and stop something I know will be very damaging. They have full court press prepared. This is not a minor effort. They will be extremely thorough on both the legal and social spheres. That, again, seems more threatening. That seems more extortionate. That seems not great. Deterring these types of scorcher tactics, waging a powerful man, lashing out his victims is the precise reason that this exists. Whatever. Let's see. Do we want to read anything more of this? Let's see. We got some legal authority for the act. Freedom of speech is good. This is our means of doing it. Can't show it clearly and convincingly. Cannot show clearly and convincingly. Cannot show clearly and convincingly. They have a qualified privilege. Let's see what they got in terms of qualified privilege. The moving part establishes by prominence each essential valid to know. Qualified privilege. Ms. Rial is a person assaulted at Ms. Toy's offense has an interest in investigation as a result, right, and right to be descended from attack online. Well, maybe that's why the judge dismissed those claims for the tortious interference because of this qualified privilege analysis. So maybe that's what's going on here. Oh, there's a footnote. This is going to be very helpful. Qualified privileges against defamation exist at common law where communication is made in good faith and the author, the recipient, or the third person or one of their family members has an interest that's sufficiently affected by the communication. Okay, so they're basically saying because it was related to their employment, they communicated to their employer. If they did an investigation, they fired them. They communicated to other people. Okay, that sounds plausible. Maybe that's the rationale for the judge dismissing as qualified privilege. If that was the rationale, that sounds about right. So that I understand. Okay, cool. Plaintiff is liable proof. No. Finally, setting aside the massive causation problems plaintiff has showing, he's liable proof. He's liable proof not only because of the defamatory articles, but based on his own admissions, persistent rumors of pedophilia. Whoa, what? Plaintiff is liable proof not only because of the defamatory articles, but based on his own admissions, i.e., which means that is, persistent rumors of pedophilia have followed him for years. What the hell are you talking about? That's not an admission. Okay? I.e. means that is. E.g. means for example. So when you say I.e., that's saying I'm going to say the exact same thing, except in other words. E.g. means here are some examples of what I'm talking about. So I.e. is I'm just going to say the exact same thing in other words. So let's read it together again. Plaintiff is liable proof not only because of the defamatory articles, but based on his own admissions. His own admissions being, that is, persistent rumors of pedophilia that have followed him for years. That's not an admission. That's not even close to an admission. What the hell are you talking about? That makes zero sense. What? That doesn't make any sense. Okay, I have to move on because I don't get it. All right, we have one more thing. We have the response to the motion to dismiss from Vic. So let's see what he has to say about it. For years, the work environment at Funimation Productions was amorous and sexually charged. Its programming is still salacious or sexual, such as panty and stalking with Gibraltar starting some people. It's all about sex and eating candy, and two fallen angels dressed as schoolgirls who wear their lingerie as weapons to fight bad guys. And prison school, where the school is ruled by a secret council of submissive female students and boys are in a world of hurt. At times, Funimation uses provocative imagery to promote its shows. In fact, this raunchy environment at times appeared at conventions attended by male actors. I'm not sure how any of this is relevant to anything. Rumors of Vic being an asshole, using fans, and being a pedophile began by Funimation's de facto manager, Chris Sabat, Monica, and Jamie in the early 2000s. Funimation nevertheless points to the tweet as whatever. Vic tweeted unequivocal denials of the charges and sincerely apologized to anyone who felt they had been less than kind or grateful, or for whom he may have felt bad or uncomfortable. He finished with a clear statement. They're completely and utterly false. Okay, great. A few days later, Ronald began telephoning and tweeting some guy, host of some show. Ronald accused Vic of assaulting 4 people. The two twins who listed with me told some guy that Sony was conducting an investigation. Criminal charges would soon be filed. Monica also telephoned someone and called Vic a sexual predator and reported that criminal charges would soon be filed against him. During these telephone conversations, Monica and Ronald both urged someone to breach his contract, despite explanations to do so would breach the written contract and refuse to continue business with Vic in the future. That does sound more like tortious interference. Ronald threatened Monica would cancel the appearance, company withdraw financial support, threatened to convince Vic debtors if they did not breach written contract. Due to disclosure from Sony's investigation, someone canceled the appearance. Some Sony employees engaged in emails with Monica thanks for making him feel at ease and helping me realize it wasn't I who did anything wrong. I know with 100% certainty that Vic assaulted 4 people I love. That would be what we qualify as a statement of fault. Thank you, Finictus, for $2 for Super Chat. I think you are the first Super Chat I've ever had in the history of ever. So congratulations on being my very, very first Super Chat. I feel validated. Thank you. I'm going to use your $2 and smile. In fact, what I'm going to do is I'm going to get a $2 bill and frame it. So, because you know, like how like people make their first dollar and they put it on the wall as sort of a symbolic thing. So, hey, I'm going to get a $2 bill and I'll put it on the wall. I'm going to have it framed and put your name on it as my first person. So, thanks. Appreciate it. And on a more personal level, thanks to everyone who's here and watching my content. I actually feel very validated just to have people here, and I feel validated by having an audience to talk to. I like to teach. I like to inform. I like to think about legal issues, and so it brings me a lot of pleasure to have someone to talk to, so that I can try to inform these concepts and distill stuff and try to like explain my thought process. So it really validates me to have you guys here to talk with, and I want to make this better so that I can bring you more value. And so thank you so much. I really appreciate it for everyone who's here. It means a lot to me. It really does. Just for just a moment of personal introspection, I deal with issues on depression at times, and so this brings me a lot of validation. It really, really does. So I really appreciate it. Anyways, carrying on. Ronald declared that Vic is guilty of sexual assault and Vic is a predator. 2 days later, Ronald publicly stated Vic is a man with a clear history of sexual deviancy. The next day, Funimation informed Vic that his contract with Funimation was terminated, but he gave no reason for the termination. Monica called Denbro to thank him for the voice and being so kind, blah, blah, blah. 3 days of tone, the truth will come out. I know without a question. People very close to me, these tears are fake. Next day, made public statements about Vic being banned indefinitely and called him a predator. Banned indefinitely is a fact. A predator is probably an opinion. Accused Vic of assaulting my fiance. Fact. 100 counts of assault. Fact. Being blacklisted and out of work. That's a fact. Being on a blacklist is a fact. And we'll get him fired for everything. That's something. I don't know if that's either fact or opinion. That's just more like being malicious. Jamie tweeted the same day that Vic is a monster. Dozen and dozen reports. Again, dozens and dozens of reports. Fact. Use name and shame to destroy reputation. Well, there you go. That right there is like, just basically like, please defame this guy, right? Yeah. Vic tweeted he did not want anyone claiming to support him making threats. Let me be perfectly clear. I never condone anything making whatsoever. I call upon people to stop doing this immediately. Well, good for him, man. Maybe it was too late or whatever, but it's nice that someone somewhere said, Let me be perfectly clear. I want you to stop harassing people. So maybe it was too late. Maybe it had been going on for 10 years at this point. But it's nice that at some point he says it's got to stop. So I'll give him a point. The next day, Jamie tweeted that Vic assaulted her. She could not remember where by grabbing hair and whispering something that she could not remember. 2 days later, Funimation tweeted that following the investigation, Funimation will not be engaging in future petitions. We don't condone any kind of harassment or threatening behavior directed at anyone. That's a pretty aggressive statement for a private company. To say we do not condone any kind of harassment or threatening behavior, what is that saying? That's a statement of fact. There was harassment or threatening behavior. I mean, that's not a throwaway line. That's a statement of fact. So that's an aggressive statement for Funimation to tweet. Because they're saying, we're basically saying, as a matter of fact, he engaged in harassment and threatening behavior. That's an aggressive statement for a private company. Monica added to Funimation's tweet that there were multiple investigations with testimony, proof, evidence. I'm one of dozens of men and women who participated. And just so we're clear, he's the legal definition of harassment. Let's see where else. Twitter followers knew exactly what Funimation was saying. The result of the investigation was they engaged in harassment or threatening behavior. Yeah, that's what I just said. Yeah, that's a statement of fact. We don't give you points in law for trying to be slightly clever. When you say we don't condone any kind of statement of harassment or threatening behavior, that is, this guy did that. It's just as good from a legal perspective. You can't say, well, we didn't say it because all we said is we don't condone it. No. That's not how this works. That's not how any of this works. 2 days later, Vic tweeted he had no idea any animosity towards him had existed until the last few weeks. Apologized if anyone made him feel comfortable and begged for people to please be kind. Ronald tweeted that Vic would be a registered sex offender. Well, the only way that's true is if you're convicted of an appropriate offense. And based on what I understand, we're nowhere even remotely close to that at this point in time. So, 2 days later, he confirmed to Monica wasn't a Funimation employee. Next day, Monica tweeted Vic had been accused of sexual harassment, alleged Vic had grabbed her hair and whispered her ear, and claimed she witnessed it do it to many people, claimed he forced a kiss on her in the mid-2000s and called him a predator. When you're talking about grabbing people's hair and whispering in people's ears, is anyone else getting a Biden kind of vibe from this? Or is that should I not mention that? Too late. Later in his deposition, a motion to dismiss, Monica explained the forced kissing story, claimed Vic invited her to a hotel room, threw her on the bed, and forcibly kissed her. That's a bit much. Let's see. Ronald suddenly switched, calling a predator, registered sex offender. If you're calling someone a registered sex offender, that would most decidedly qualify as a statement of fact. And it's a really easy statement of fact because the registry is public. So, Defendant's motion to dismiss involves 3 steps: initial burden of proof, some standards, legal stuff. Prima facie case must produce a minimum quantum of evidence necessary to support rational inference. Yeah, basically true. Clear and convincing is not a heightened evidentiary standard. It means it must prove a factual day's standard as a rational inference is true. Yeah, that's basically correct. He's not required to prove direct evidence. That's true. You may rely on circumstantial evidence. Yeah, that's true. Yeah, you absolutely can rely on circumstantial evidence, but, and there's a lot of that going on, especially with the tortious interference stuff. I mean, you're almost never going to be able to show direct testimony on that kind of thing because you have to, show that they did it because of the thing, and so you're, at best, going to get, circumstantial. But if you can show, a lot of... in the same way that they were saying that Vic is guilty because of a lot of similar events, and so you show an MO. In the same way that pattern can be used to kind of show potential guilt or increased of guilt, you can do that this other way too. So because if there's a lot of people that are canceling their contracts at the same time or disinviting them at the same time, that's a pattern of conduct too. So in the same way that the pattern can be circumstantial evidence that might lead you to think there's something going on in terms of sexual harassment, that same sort of pattern evidence can also lead you to the conclusion of the tortious interference. That this is that because it's not just one instance, it's a whole bunch of instances, and that pattern, that MO, is suggestive of a pattern of circumstantial stuff. So there's that kind of correlative thing where it's like, well, if it happens, happening once is a coincidence. Happening once is a coincidence. Happening twice is a coincidence. Happening like 5, 10 times, that's more suggestive of something. So like it's less likely to be aberrating. And I'll say exactly what I said before in terms of the accusation. Just because you have one accusation doesn't mean it's false. Just because you have 100 doesn't mean it's true. Just because one guy fired him doesn't mean it was because of this, and just because 100 people did this doesn't mean it was because of it either. So it's the same way. It's like it's not dispositive. It's just providing some sense of like, okay, well maybe there's some more here that like, just 100 people saying it makes it a little less likely for it to be false, right? That kind of thing. Okay, someone asked, it's more prudent to say maliciousness describes an act rather than thought or motivation, or you might be wrong. Well, this is where we have to be careful, and why I didn't like it before when they used malicious in two different contexts, because malicious means two different things. When they were talking, so let's talk about malice in defamation law. In defamation law, when you say that someone is acting with malice, that doesn't talk about their intent. It doesn't talk about their state of mind. It doesn't mean that they think that they were mean. It doesn't mean that they hated you. In defamation law, malice means essentially reckless disregard of the truth. It means that you were aware or should have been aware of what was true and blatantly ignored it. So being malicious in defamation doesn't mean that you were desiring to be mean. It doesn't mean that you were desiring to be hate. It means that you were being recklessly ignorant of what's real. Versus what malice meant in the case of the tortious interference case, because they used that same exact word, malice. And then when they used that word, I actually said at that time, it's like, well, I wonder if they mean this literally or if this is a mistake. And someone said, oh, he means it literally. Because they used it there to mean, oh, they actually hate you. So in defamation law, malice doesn't mean hate. But in the tortious interference case, it does mean hate. So it's the same word, means two completely different things. So it's just a little confusing. You have to keep that straight. So just be clear. Where was I? You must presume the truth of the assertions. Absolutely true. Vic satisfies the burden. Court must dismiss if they can establish each and element of the defense. Yep, fair enough. The communications are not subject to the anti-SLAPP protections. The anti-SLAPP protections is to strike a balance between the citizen's lawsuit designed to shield First Amendment and rights of persons to file meritorious lawsuits. Yeah. You can't file a lawsuit because someone is mean. You can't file a lawsuit because they're making up lies about you. A motion to dismiss under the anti-SLAPP is manifestly not intended as a means of disposing of meritorious suits. Yep, that's true. All defendants argue Vic's claims are based on or related to or response to the exercise of freedom of speech. They define it as an exercise of freedom of speech as a communication made in connection with a matter of public concern. Defines freedom of speech has two components. The exercise must be a communication. Communication must be made with public concern. Public concern involves an issue related to health or safety, environmental, economic, or community well-being, government, public official, good or product or service in the marketplace. Well, I mean, based on that definition, this seems like a matter of public concern to me. I mean, it goes directly to health or safety issues, especially if you're communicating within your own company. So that definition is not particularly helpful to Vic, it seems to me. The mere fact the topic relates to the controversy does not mean it's a matter of concern. That's true. Public controversy is not the same thing as public concern. Very true. Speech deals with public concern when it can be fairly considered as relating to political, social, or other concern or subject of legitimate news. Yep, that's about right. Prosecution crimes are public concerns. Yep. Let's see. Funimation argues its tweets were made about health or safety or community well-being or animated community. Yeah, that's what I'd be arguing if I were animation too. That's Funimation too. That's exactly the right argument. Funimation fails to provide evidence or argument defining this amorphous anime community. That's a very fair counter-argument too. Does this community include every human on the planet? Funimation provides no evidence or argument identifying the community whose well-being is a matter of public concern. That's a very, very fair concern. That's a very, very fair concern. If it was just within their own company, if they communicated to their own employees, if they sent out a company-wide email saying we fired him because of this, even if they communicated to like other providers or they communicated to other convention people saying that, they make a much more plausible argument. A global tweet is pushing it too far. I think Vic has the better end of the argument here. Source of tweet related to public concerns, a public figure. Blah blah blah. They got two people wrong, so they mistake one name for another. Okay, fine. That's a big oopsie, but still. Public figures fall into two categories: general purpose and limited purpose. The general purpose is someone who has pervasive fame, well known, household word. Private individual is not accepted or in influential role. He's not a public figure. He's not a well-known celebrity. Yeah, I would tend to agree with that. Numbers alone cannot establish public figure status. Yeah, that's fair enough. It's a little conclusory, but it sounds about right. Limited purpose public figures, only public figures for a limited range of issues. Texas uses a three-part test. The controversy issue must be public both in the sense that people are discussing it. People other than immediate participants are likely to feel the impact of the resolution. Well, that blog and Tumblr and whatever else they referred to seemed public enough. And I think you could get to the likely of impact element. The plaintiff must have more than a trivial or tangential role in the controversy. Well, that we've got in spades all day long. And the alleged defamation must be germane to the plaintiff's participation in the controversy. Also got that all day long, 4 days. So basically the only thing that we're really at issue is element number 1. Element 2 and 3, you're meeting without blinking an eye. Alleged statements cannot be what the plaintiff's brought into the public sphere. Those charged with defamation cannot by their own conduct create the defense by making a claim in a public figure. No, that's not what that means. The allegedly defamatory statement cannot be what brought him into this public sphere. I think that's misapplied. In considering the plaintiff's role in the controversy, the court considers where the plaintiff actually saw publicity surrounding the controversy, where the plaintiff had access to the media, and where the plaintiff voluntarily engaged in activities. Well, it seems like we got that too. Funimation does not explain what the behavior alleged was negative Twitter posts. The reference constitutes no evidence of a public controversy. Well, the question would be whether it was public controversy within the meaning of this before Funimation did whatever. And based on what we've learned from the various blogs and Tumblrs and stuff, and these lists that apparently were circulating and stuff like that, it seems to be a matter of public concern within the relevant communities. I mean, if there really were blogs where like dozens or whatever of people had documented stuff, then that seems to fall within the scope of that. So yeah, Funimation's tweet is definitely not going to get them there. But some of that preliminary stuff I think is going to do it for them. Funimation has no credible evidence Vic voluntarily engaged in activities. Well, I really, really hope for Funimation's sake that's not true. Because Funimation said we don't tolerate this. They better have they better have credible evidence from their point of view to be able to make that kind of statement. Funimation better hope that they have it. So, the fact that they said it makes me think that they think it's pretty credible, because that's ballsy, in my view. I let me put it this way: if they asked me if I were their corporate counsel, I would be looking across the hall, being saying, "There be dragons." Let's not do that. Funimation fails to provide any evidence that anyone other than Vic and defendants will have impact of any resolution here. Well, no. Seek out news media. He merely asks his supporters to publicly speak about their positive experiences. Ooh, yeah, that's true. That's a problem for you, Vic. I forgot about that. That's going to hurt you bad. Yeah, if you're asking your supporters to publicly speak on your behalf, guess what you just did, Vic? You just basically made all these people your agent. Yeah, you just basically deputized all these people as your agent and said, as my agents, I want you to go forth and do this. I want you to go publicly to go forth and deny these allegations and engage on this. Ooh, That's not good, Vic. Oh, I think you might have hoisted yourself on your own petard on that one, boy. Ugh, rough. Vic neither sought this controversy nor injected himself into it. He kind of did there, Vic. He kind of did there, Vic, when he asked everyone to like go into Twitter at all and like tell everyone what a great guy you are and deny all that and defeat the lies and all the rest of it. It's like, yeah, that's kind of you just deputized everyone as your agent, man. That's yeesh. Yeah, that's not going to help your claim there, man. Um, Fundation's claims tweet merely state it was parting ways with Vic after the second season, but fails to state how status of the contract is of general interest and concern of the public. Well, if all the tweet was we are not going to continue employing this guy, like, well, that's kind of true, and like, I don't know if that's routine or not, but it doesn't strike me as defamatory. Like, we're not going to have this actor anymore, and we're going to go with someone else. So, like, that seems okay. Is it referred to in legal circles as an oopsie? I'm like, man, it's not encouraging. It's a little hard to make the argument I didn't engage the public when you then say all I did was ask the public to engage. It's like, yeah, those two thoughts don't really gel in the same universe. There's a bit of a logical problem there. If Fundation's arguments are to be believed, the tweets merely state it was parting ways and asked the community to be kind to one another. The tweets were not based on or related to the public concern. Well, if what you're suing on is a tweet that says we're not going to continue working with this guy, we're going to work with someone else, that's not defamatory. That's just like factually true. I mean, I'm not sure that you could probably sue maybe under like a different theory. You could sue under some sort of like, basically making private business public kind of thing. You can make invasion of privacy kind of arguments, but it's not defamatory. And to the extent it's routine, it's like, and it strikes me as the kind of thing a company would do. Like, if an actor's going to leave and you're going to bring in a new actor, you might want to like let people know who are fans of the show. So that doesn't strike me as like inherently odd. So eh. So the we're not going to continue hiring this guy and we're going to bring in a different guy and it won't affect the quality of the content seems perfectly benign. We don't tolerate sexual harassment and stuff is not benign. Those are very different tweets. It's axiomatic the claims involve an important matter and they need to show no more. It burns under the statute. Yeah, relying on hearsay is not relying on hearsay, speculation, and other inadmissible testimony. Well, it might be admissible. Do we want to go through the hearsay exception rules? We don't have time for that. Relying on hearsay, speculation, and other inadmissible testimony, the positive rumor and allegations about Vic were swirling for about a year. A proposition flatly rejected by a 28-year veteran anime actor. What? Are you referring to yourself when you say that? Are you referring to yourself when you say 20-year veteran anime actor? Please tell me you're not referring to yourself. I'm going to go back up to footnote 12. Where page am I on? I'm on page 19. I'm going up to footnote 12. Who are you talking about? Oh, you're talking about this Chuck Huber guy. Fine. Did that. We did that. Did that. He argues he's a general purpose public figure because he's a fan club. No. Voice actor with hundreds of anime films. No. Has a GoFundMe started by a Missouri attorney? No. Particular number of Twitter followers? No. Allegations against him in public disgust? No. None of which is evidence he's a public figure. I agree. No. But thank you for trying, but no. He argues he's a limited public person figure because he attracted limited media attention. Concludes that there's ample evidence in court. Multiple people are discussing the statements. He's the center of controversy. He's ejected himself directly into it. Yeah, well, he did that in spades. He got that going for you all day long, apparently. Jesus. And far beyond a merely tangential or trivial role therein, statements of which Vic's complains are generally germane to the controversy. Aside from the threshold issue, her arguments fail for the same reason. Jamie claims her tweets relate not only to her own safety but the safety of other victims. That's not going to quite fly, guys. You can't just say like, you know, someone as a sexual harasser obviously goes to your own safety and the safety of other victims. But if it's a false statement, you can't hide behind the idea that it's for the safety of people. You can't allege that someone is like a danger reprehensible monster and then say, well, it's okay because I'm just concerned about people's safety. That doesn't quite fly. Vic has vehemently denied allegations made against him. While Texas courts may recognize when a statement concerns even justifies individual safety, the statute applies. The statement, which has changed initially since it was made by her, made years after it claimed it happened, is not impacting her safety in any way. Well, if she's reflecting statements that actually happened to her, yeah, it does impact her statement safety. I mean, if you assaulted me 10 years ago, that is still relevant to my safety today as far as I'm concerned. So I don't know what you're talking about when you say that. Continuing on, she had contact with Vic on multiple occasions after she claimed she assaulted her, which indicates she had no concern for her safety and well-being. Well, that's just, that's a little bit off point. Do we need to like point to all the times that people like who were previously assaulted continue to have contact with their assaulters? So that's not really dispositive of anything. If she was so concerned about her safety and health, is concerned about the safety and health of what she claims are fast food students, then why she wait years to make her statements? Ooh, no, I would not go this way. Oh, this is not a good strategy, my friends. Oh, you don't want to say things like that. You don't want to make that kind of. That's not good lawyering. Oh. She provides only a self-serving statement and no other evidence to demonstrate her concern for others. An issue is not automatically a public concern because it could become one in the future. Well, that I'll agree with. Jesus. The statute does not protect the unfettered right of speech, but expressly protects the right only to the maximum extent published by law. Sure. That doesn't impact the right of freedom of association. Blah, blah, blah. Sure. There's no constitutional value in false statements of fact. I would agree. False statements that defamed him and proves damages. Yeah. And so we got elements of that. We got various statements made by people. Yep. And I think that we got that right. It was a degree of fault. He's a private, not a public figure. The judge says limited purpose, public figure. Well, if he wasn't a limited purpose public figure for any other reason, when he asked his Twitter friend to go forth, like the monkeys from the Wizard of Oz, go forth, my pretties, go forth. Yeah, that was not. If you wanted to be a private person, that's not really how you do that, my friend. There's some damages. We got some tortious interference stuff. He had contracts. Tortious interference stuff looks right on its face, but then there was that argument about it being privileged because of the business relationship of the people making it. So if the judge dismissed the tortious interference stuff because of that privileged element, that would be really interesting as a matter of law if that was his basis. So it'd be really interesting to see when he makes a decision, if he makes it publicly, if he says that's the rationale was because of that qualified immunity or that privileged element, that'd be a really, really interesting ground. That would be legally interesting to me. Established prima facie case of conspiracy? Sure, why not? This vicarious liability? Yeah, that's easy. Vicarious liability is easy. They're employees of the company. I mean, end of analysis. Failed to establish any affirmative offenses. Oh, so he some qualified privilege stuff. Statement was made without malice. The concerned statements and their party. Yeah, I think we got that. Malice means statement was published with knowledge was false or reckless disregard. That's why I was saying it doesn't mean meanness. It means blatant ignorance of the facts. Liable proof. For defendants to prevail on affirmative defense, they are liable proof. They must show engaged in antisocial criminal behavior and its activities were widely reported. A liable proof plaintiff is one whose reputation on the matter issue is so diminished that at the time of otherwise libelous publications, it could not be further damaged. Well, okay, apparently this is a Texas thing that exists. Apparently your reputation can be so bad, it's impossible to further libel you. This is Texas law. I'm not sure I agree with that as a matter of principle, but that's okay. Texas can have that as its law if it wants. It shall have only limited application. There's very so few and pure that cannot be traduced. I like that word. And while a person's general reputation may be so bad as to render him liable proof on all matters, ordinary even public outcasts remain good reputation is entitled to protection. Yeah, I agree. He alleges libel proof based on the articles his own admissions that rumors of pedophilia have followed him for years. That is not an admission. What are you talking about? Rumors. I saying that rumors of pedophilia have followed me is not an admission. What are you talking about? Defendant does not demonstrate how Vic has engaged in any antisocial behavior. They provide no criminal history. They only have rumors. Some of the defamatory articles that claim they're libel proof were published after the termination, after defamatory statements were made. Yeah, that's fair. If those defamatory statements were made afterwards, then like they're part of the problem, not a defense. So it's like, yeah. And they were widely reported to the public. So my gut analysis on this, based on what's here. Now, of course, at this stage, we're in a motion to dismiss, right? So the standard for motion to dismiss is failure to state a claim. Failure to state a claim, we are assuming, as a matter of law, that all Vic statements are true. Because the argument is that even if they are true, the defense should still win, is the standard we're trying to reach. So even if everything Vic says is true, should the defendant still win? That's the question we're trying to reach right now. So there's a lot of things here that are obviously issues of fact. Well, did they say this? When did they say this? Who said it? When did they do this? When did they do that? Who said what to whom and when and how was it communicated and by whom and when, and which parts of it were privileged and which parts weren't, and so forth and so on. And what did they have to rely on? What was their basis for making the statements? Their underlying truth, all kinds of fun stuff. So, at least on gut impression, I think Vic has made a seems plausible case. It seems reasonable. The tortious interference stuff is really interesting. If it pins down onto that qualified privilege stuff, if that's the basis, that'll be a really interesting basis for dismissal. And of course, there's the statute of limitation stuff. So the statute of limitation stuff, if that's true, well, you're just dead in the water. So I don't know if the judge has ruled on that. Apparently he's only dismissed some of the cases. So I guess some of them must be alive on the statute of limitation stuff, or maybe he's reserving that part of the judgment. So, if they can prove statute of limitations, game over. If they prove that qualified immunity, then, game over. I'm not Brandon. Are you talking about me? I'm not Brandon. Brandon's a different guy. Don't. Brandon's a different guy. Anyways, carrying on. Yeah. So it seems like there's enough here on the same thing. Yeah, tactical process, lol. They do get our voices confused, tactical. It does seem to be a thing. So I don't know. One of us has to change our voices or something. Yeah, this is Uncle Blackleaf. Brandon's a different guy. The way you know the difference is that Brandon tends to apologize a lot, and I most decidedly don't. Anyways. Yeah, we're very different in personalities, too. Anyways, but it seems initially plausible on its face. Yeah. And a lot of these statements may be before the statute of limitations, too. So you would want to, a lot of these statements, like the stuff that's been following him around for years, like all those statements, they might be out of the statute of limitations reach. So we're only trying to get to the statements that are within the limitations. It looks like the statements that were involved in him being fired as an independent contractor by Funimation or whatever are basically the statements we're looking at. To those statements and those people who made those statements and whether or not they're true or not. Now, to the extent they're talking about things that actually happened to them, I mean, unless they're just flat out making it up, That, I mean, that's pretty much like, if this is what happened to me, I mean, that's pretty good, right? I mean, it's a statement to the fact they're relate. If they're just merely stating, well, these are things other people said, that's good. But it's like if you're going to say things like there's 100 statements and he's going to be convicted and he's going to do this and I know he did this, I know he did this, and I have 4 friends I know for a fact, and there's corroborating evidence which has a specific meaning, by the way. If you're going to start saying things like that, man, it better be true because his reputation's been hurt. I do, and that part where they said, yeah, he's conceded that his reputation's been hurt. What do you mean he's conceded? His entire argument is that his reputation's been hurt. He didn't so much concede it as allege it and scream it from the rooftops. What are you talking about? So it's like, yeah, man. So, I don't, apparently in the community at large, there's a lot of people really, really upset about this and people who are really like whatever. I mean, you know, I'm just looking at the law. I don't know anything about this case except what I've been reading, and you know, some pretty plausible allegations, some reasonable defenses, some good legal defenses in particular. With like that qualifying immunity is a fantastic legal defense. The statute of limitations, fantastic legal defense. The anti-slap provisions, very reasonable. But I think there's enough for discovery. There's enough to go forward. So on initial impression, yeah, it seems okay. So, and if from I would be interested perhaps if I were one of the defendants for this case to go forward because it's like if it's really true, if all these things are really true, like the nice thing about lawsuits is like discovery goes both ways, evidence goes both ways. There was like a 500-page deposition with Vic, which I most decidedly did not read because it's like 500 pages where they get to ask him all kinds of questions and ask for all kinds of discovery. So maybe the truth will out in the end. And maybe if this is true, maybe all this will result in all of that being shown to be true. So hey, maybe that will be good. And there have been allegations that his lawyer screwed the pooch. I don't have anywhere near enough evidence to render an opinion as to that. As to like the way it was written, I thought on balance the defendants was more poorly written. But that's more a stylistic thing because they had this lot of this purple prose and high adjective stuff that I really don't care for, and that's more stylistic. But they were really good on some elements of law. They were really sharp on some elements of law. So they both seem like pretty competent attorneys. So whatever. So that's all for today. I hope you enjoyed the stream. Please like, subscribe, hit the bell if you haven't already done those things. As you've noticed, I've been trying to put out content every day. I usually put out a story around 4 o'clock or 5 o'clock. And so I already have stuff for tomorrow. And I already have a list of things that I'm recording. I'm still debating on like a recording time. Last time I did it right after Leonard's stream. I don't know if we'll do that again, but we're still playing with the time and we're still playing with the channel's name. So if you have suggestions for the channel's name, let me know. As you know, we're currently branded under Internet Law Review, but we have some competing suggestions. We've considered Law Time with Uncle Blackleaf, or Uncle Blackleaf's Law Time, or Uncle Blackleaf's Law Emporium, or Uncle Blackleaf's Crazy Law Experience. I don't know. What do you if you have suggestions, let me know in Discord. And if there's a judge's decision or more content on this, I'll do a follow-up video to this. Anything that gives me something to analyze and something to explain and something to say, yeah, I agree with this, or yeah, I disagree with this. And the judge can explain his reasoning. I can say, yeah, I think that's right, or I think that's wrong, or see what it's got. But so far, so good. So we'll see what's going on. So people said this was a dumpster fire of a story. I mean, to me, it doesn't seem very dumpster fire-y. I mean, to me, it seems like, sorry, guys, seems kind of like a fairly routine, run-of-the-mill lawsuit. I don't know. Seems pretty normal to me, so I don't know. Uncle Blackleaf's Juris Circus, that's pretty good. Yeah, so let's see if there were any questions before I sign off, because I was reading a lot, and so I couldn't read both at the same time. See if I skipped anything before I sign off. Minyahe, Mignogna. I keep trying with the name. It's a little rough for me. I'm doing my best. Are we demonetized? Apparently not, because I got at least one super chat. That was nice. Rumors aren't fact. Yeah, that's very true. Yeah, maliciousness describes the act, not the motivation. That's basically correct. It's maybe not the most wonderful term of law, but that's what we came up with. So that's what we're all stuck with together. God will strike you down. Is that defamatory? No, that's not defamatory. It's not a statement of fact. And even if it's a statement of fact, it's not false. It's it's not even intended as a factual statement. It's not like, and it's also prospective in the future. He will do something, and so it's not really a factual statement. It's a prediction, right? We definitely had a few legal oopsies. You want to know about hearsay exceptions tactical? Oh Lord, we do not have time for that. Hearsay exceptions when something is excited. Yeah, excited utterances. There's a really lame video that is so old about hearsay exceptions. Should we watch the really lame old video about hearsay exceptions? Let's watch the really lame video about hearsay exceptions. I immediately regret this, but we're gonna do it anyway. Because you guys should have to deal with the same wonderful stuff that I've had to deal with in my time. All right, are you ready? Are you ready for this, guys? Is your soul prepared? Your soul's probably not prepared, but we're gonna do it anyway.
When Samuel was standing at the curb, he saw a little pacer going 75, flew through the intersection, hit a pedestrian, and Sam excitedly uttered a hearsay exception. Whoa, a car crash! Ah, that guy's out of control! Hey, what kind of idiot is driving that pacer? Hearsay exceptions are excited or surprised when in the rest chesty category it is said that it is the offense speaking through the statement. Nancy took a pill that made her ill. She went to the doctor to complain. At Doc's suggestion, she described her affliction. Unless for litigation, it's a hearsay exception.
That pill made me throw up. Whoa, I see spirals. I don't feel too good, Doc.
Hearsay exceptions can be physical or medical. If it is sufficiently clear that the statement is trustworthy, then a cross-examination would be moot. When a statement is excited or surprised,
Wow.
the present state of mind,
I'm scared.
present sense impression
Whoa.
related to a diagnosis,
Ugh.
but not for litigation.
I'm gonna sue you.
An 803 exception gets it in. Frankie said he punched Jim in self-defense. He had said that he was scared of Big Jim. Sue heard him say so before the fray. So as proof of state of mind, it is a hearsay exception. Hell, he's gonna kill me.
Jeez, that guy's scary.
I have to punch him to survive. Hearsay exceptions can be proof of state of mind. When in the rest chesty category, it is said that it is the event speaking through the statement. When the statement is excited or surprised,
Wow.
present state of mind,
I'm scared.
present sense impression,
Whoa.
related to a diagnosis,
Ugh.
but not for litigation.
I'm gonna sue you.
An 803 exception gets it in. Hearsay exceptions, 803, 803. When in the rest just a category, it is said that it is the event speaking through the statement. Hearsay
exceptions. Memory, perception, narration, sincerity, trustworthiness.
Okay, so now you know about hearsay exceptions. So aren't you glad you asked? Also, a big one not mentioned in the song is statement by a party opponent. So if I'm suing you and I'm quoting something you said, it's not a it's a hearsay exception because it's a statement by a party opponent. So that's a big one that they did not mention in the song. Hey, I watched that video when I was in law school. So it helped me study for the bar. So I'm just saying, whatever works, man, right? That's how it goes sometimes, yeah. So now you know about some of the wonderful hearsay exceptions. Excited utterances. Also, a classic one. Statements made when someone is in contemplation of dying is another hearsay exception. So if a person has a reasonable belief that they are dying, even if they don't actually die, it's a hearsay exception. The idea being that person is not lying while they're dying. So that's another classic one that applies at common law. Dying man's last words was exactly what I just said. Yeah, if you're in contemplation of death, it's an exception. You don't actually have to die though, so that's a plus. Conjunction. No, we're not doing that song. I think one law related video for a day is good enough. So yeah, I whenever I think about hearsay exceptions, I mean I saw that video 10 years ago and it's still in my mind. Hearsay exceptions in three. Federal rules of evidence, man. Oh my God, I studied that class 10 years ago. And song's still in my damn mind. Maybe that's why I passed the bar exam. Mood if they don't actually die if they could ask you directly. Well, not necessarily because okay, everything has exceptions upon exceptions, but there'd be a reason to don't worry about it. Maybe not. Maybe you died for some other reason, in the intervening time, right? So because hearsay exceptions would be a thing if witness is not available. So if you're not available to testify, it's a hearsay. It's hearsay. So yeah, I could ask you directly, but what if I can't? Can I get that statement in anyway? Well, now I can because it's a hearsay exception. So the fact that I don't have you is not relevant. So if I can ask you, great. But if I can't, I can get it in otherwise because, hey, if they fled to another country or something else or dead or whatever, something could happen in the intervening time. So there you go. So I'm glad that was super helpful. Hey, man, things happen. It's like in criminal law, that's one of the major reasons for the defense to want to stall. Because the probability of one of the witnesses dying or being unavailable or something is not trivial. And if that happens, then it helps your case substantially as a defense. So it helps the defense to stall. If nothing else works, stall forever. Because your case is only going to get better. A person plead the fifth. Person pled the fifth. Yeah. So if they pled the fifth, you could get their statement in. Well, that would make them, but that makes them unavailable. So there's a wonderful thing for you too. So you say the witness is unavailable. When you say that, it doesn't necessarily mean that they're not physically available. It's so if I call you to the stand and you refuse to take the oath or take the fifth, as far as the law is concerned, you're unavailable. You're unavailable as a witness. So that would make you unavailable. So yeah, the same thing. So there you go. And he's graduated, but he didn't pass the bar. He didn't pass the bar? That's very sad. He didn't take it more than once? I mean, I passed the first time, but I know a lot of people who didn't. I thought it'd be interesting. I keep threatening one of these days if if I get 10,000 subscribers or something, I should take the bar exam cold with no prep and see how that goes. That would be entertaining. I don't know how good my scores would be, but it could be embarrassing / interesting. Unless they ask me about Blackacre, which, as Tactical will remember from our conversation earlier today, I had a bad reaction to it because I don't want to talk about Blackacre. Horrible things happen there. It's not a happy place. Yeah, my understanding is he's a practicing lawyer. I don't know either way. I mean, he certainly has his Ricardo law. I think he's a practicing lawyer. I mean, I don't know. I mean, so I don't know. Anyways, guys, that's all for tonight. I hope this was helpful. I hope this was enjoyable. I had fun with it. So if the trolls want to comment on me and whatever, yeah, you want to mention the rule against perpetuities. The rule against perpetuities is a total pain in the ass. Don't just what I learned from the rule against perpetuities is like don't even try to get anywhere near it. And in case you're wondering, it deals with wills and like when gifts and wills have to be given, and don't worry about it. It should never pop up in the real world, and it's a total pain in the ass, and everyone hates it. So just don't worry about it. Should do the non-sex show thing, whatever that is. I'm loud. Don't you have a license to practice lawyer? Yeah, you do. You have to have a license to call yourself a lawyer or attorney. You have to be barred somewhere. I actually know a case where that happened to a guy. Well, I know of a case because I don't know directly. I read it in a book, right? Like so many things. But I know of a case where a guy graduated law school and like sat for the bar and in the interim got business cards that his name and ESQ at the end. And the bar actually like prevented him from being a lawyer for a year because he wasn't a lawyer yet. And ESQ means you're a lawyer. And so I thought that was a little mean, a little over the top. I mean, I understand he was cutting it by a little bit. And, you could take the position that, lawyers should know the law and stuff. I'm like, man, oh man, get a break. Jeez. But they barred him for a whole year because of that ethics violation. I'm like, Jesus Christ. Man, oh man. One of these days, I should tell the story about my being grilled by the bar over our desk lamp. That's a good story. Not for today, guys. You have to wait for that one. Oh man, later, guys. I love you all. Cheers. Later. Bye.